Right, you are welcome to this very video. My name is Lucky O Iwedose, PhD BL Esquire. I am a legal practitioner. Today, I will be giving a lecture on a particular topic, which is a part of medical law, and it is to be found in this book that you are seeing on the screen, Medical Law and Forensic Medicine in a nutshell, from clinic to courtroom. Also, next to this medical law book is the National Health Act 2014. That is the Nigeria National Health Act. So you are welcome to this very lecture. So I'll be taking us on globalization of patient rights. As you know, the healthcare of today is no longer confined to local hospitals or national boundaries alone, because the world is becoming smaller in terms of being a global village. So, which means today, by the process of telemedicine and digital health, we can have expanded healthcare access or reach to so many persons across the globe, and even those who were before now in who were living in underserved communities. Today, patients can compare global standards and demand similar rights locally, and of course, this give them some impetus to be able to know what is happening in other parts of the world where they have never visited or that they don't even reside in. Medical practices are now exposed to global scrutiny as a result of this. Now, the impact of globalization is one: patients can now access international patient rights information, because before now, the right of patient was like localized in the sense that many patients could not have access to what their right should look like as a patient. So as a result, so many things were done, and some erring healthcare professional could get away with those things unnoticed. Again, courts worldwide today address patient rights issues publicly. This is because it is the court is a public institution. So what takes place in the court can be heard and broadcast throughout so many e-channels, because there is nothing like secrecy about it, no confidential uh, information about how court should conduct their proceedings. So as a result, apart from some few exceptions, so what is done in a hospital, in a local hospital, so to speak, can become a matter of international discourse, and how a court responds to the infraction by a healthcare professional in a particular local hospital could become a matter of international discourse and responses also. Therefore, healthcare providers must meet global expectations. This is to say, if you as a healthcare provider, you think that you are just in one corner of the globe, you are living in an isolated area, that your activities and the action cannot be brought under international scrutiny. So you have to have a rethink, because things have really changed a lot, and there is a wider scope today to which your information or your action or inaction or conduct or malpractice or negligence can go. Therefore, healthcare provider must be very mindful of how they relate to their patient in the contemporary world. This, of course, is helping to increase accountability across jurisdiction. because with the growing awareness among patients of their rights, even healthcare providers have to sit up and be very mindful of the way they relate with patients and how they go about uh, conducting care or treatment for their patients. This, of course, like I said before, help to instill some level of accountability across jurisdiction all over the world. Of course, there's what you call cultural exchange in healthcare. Today, there is mass movement of people from one place to another, from one geographical location to another, from one continent to another. And each of these migrants or travelers have expectation as far as healthcare is concerned. Maybe because of the way they are being treated in their home country, they will expect such treatment to be given to them when they go to another jurisdiction, especially when their whole country is such a place that is so favorable to patient welfare and interest. For example, a patient that is well catered for in the jurisdiction is well pampered, is well respected, and is well honored when he or she seeks treatment. We carry that kind of cultural belief to another jurisdiction. Supposing in that jurisdiction, the patient is not treated in that humane manner, definitely that will make the patient to react and think that his or her right is being violated. So poor treatment, therefore, in one jurisdiction can fuel advocacy and reform by the impact of a very good kind of treatment received in another jurisdiction. Of course, in the same way, government align laws with international standards because of the way things are being done globally, and also the way with which information now travel from one part of the world to another. This is inducing a lot of government to make sure that their laws are aligned with international best practices. For example, we have the African Charter on Human and People's Rights, a part of which takes care or makes provision or articles for the right of patients. So, in that respect, countries, for example, all over Africa, and subscribe to that African Charter on Human and People's Rights. So, which means even in their home government or within their national jurisdiction, such government have to ensure that they come up with laws, rules, and regulations that govern healthcare services in their country with respect to international standards. Human rights framework help also to shape patient rights. So in this case, you will agree with me that, like I said, like the charter, um, like the articles that are in the Africa Charter on Human and People's Rights, will go a long way to ignite human rights advocacy for better healthcare treatment and attention. So I will stop here so far. In my next video, things will be explained very well. So I invite you to have a copy of this book where everything concerning medical health, medical law, and forensic medicine are discussed, and you have a lot to benefit. Thank you very much.